back. This is the Thursday edition of All Angles here on eNCA. Now, the Constitutional Court has ordered former President Jacob Zuma to appear and give evidence before the Zondo Commission. Presenting the court's judgment, Justice Chris Jafta said Zuma is legally obligated to appear and testify before the commission and to obey all summonses and directives. For reaction to that judgment, Lawson Naidoo from the Council for the Advancement of the South African Constitution joins me now via Skype. And Lawson, important to state up front that you were amicus curiae in this particular case, friends of the court. It wasn't as clear-cut and as straightforward as many would think it was, Lawson, was it? Because at some point the court was asking probing questions of the commission to say, why did you not just issue the summonses to Mr. Zuma very early on, and why should you not pursue that process to make sure in other courts and say, actually, you need to adhere to the summonses? Why should we intervene in this particular case? But in the end, it went in that direction that the court has issued those directives.
Yeah, look, Thulasizwe, thank you. I think, the court started off, Justice Jafta, in reading out the order this morning, being critical of the conduct of the Commission in not dealing with this issue of Jacob Zuma earlier, that they should have issued the summons earlier and so on. And so having been critical of the conduct of the Commission, the court ultimately decided that they would grant direct access on the basis of what was in the interests of justice, taking into consideration former President Zuma's conduct in relation to the Commission, and I think that opened the door to granting the direct access, and the court then gave judgment on the merits of the case that was brought by the Commission of Inquiry, in which, as you say, CASAC, together with the Helen Suzman Foundation, were admitted as amici.
We don't have the benefit yet, Lawson, of the full judgment in terms of the other issues that were ventilated during argument in December. So we're not clear, for instance, on the issues around the office, the constitutional office that Mr. Jacob Zuma occupied at that particular point, and why he should then be accountable for him carrying out the duties of that constitutional office. But I do imagine that those were important considerations in the eyes of the court, in that, you may not be keen to answer what people are saying about you as Jacob Zuma of Nkandla, but as a former occupant of the constitutional office, you actually have an obligation.
Indeed. I also haven't read the judgment as yet. I've just received it just a couple of minutes ago. But what Justice Jafta did say this morning, and he emphasized the fact that it was Jacob Zuma, when he was still the president, who established the Commission of Inquiry, promulgated the directives under which the Commission operates, and now Mr. Zuma seeks to subvert those. And the Commission clearly, the court clearly took a dim view of that and of the conduct of Mr. Zuma, which ultimately led the court in an important part of the order to say that Mr. Zuma must pay the costs of the Commission in this application, even though Mr. Zuma, did not participate in the matter. He was the respondent, and it was his conduct that gave rise to this application by the Commission, and therefore he has to pay the costs.
How significant is this settling of this issue around whether or not witnesses have a right to remain silent? It became as a kind of an issue that came up when Dudumieni was testifying. In the end, of course, she framed it along the lines of, may I invoke the privilege to not answer that question for fear of incriminating myself, which is quite different from saying I have the right to remain silent. Now we have the highest court in the land almost settling this question once and for all, whether witnesses have a right to remain silent at the Commission.
Yeah, I mean, I think there are two parts to that issue. Thulasizwe. Firstly is the right to remain silent, and the court was unequivocal in saying that the witnesses before a commission of inquiry cannot claim the benefit of the right to remain silent as a blanket right, that they are there to answer questions that may lawfully be put to them by the Commission and its legal team. And then there's the issue of the right against self-incrimination, which is an issue that CASAC in particular argued before the court, that we argue that the right against self-incrimination should not extend to persons before a Commission of inquiry. The court differed with that and said that the right is contained in the Commissions Act in Section 3, subsection 4, and that witnesses before the Commission may lay claim to that right. But again, they cannot lay blanket claim to that right in the way that Ms. Dudimieni did, by simply saying that she refuses to answer on the basis that it might incriminate her. The court here seemed to go a little bit further in saying you have to show just cause why answering this question might give rise to self-incrimination. So Mr. Zuma is going to have to do some work to try and evade answering questions by explaining why answering such a question may incriminate himself. So that's a big step forward, I believe, in this judgment, but we'll have to see in the detail of the judgment exactly how far that condition goes.
Yeah, it is significant, is it not, Lawson? Because my recollection, for example, of the testimony of Dudimieni is that requirement to show why the question, your answer to the question asked, may lead to you incriminating yourself. My recollection is that there was not a requirement. She could, be asked, when did you arrive at SAA for the first time, and simply say, I cannot answer that question for fear of incriminating myself. So you're saying, with this judgment, the likelihood is that former President Jacob Zuma will need to show how exactly he believes he will self-incriminate.
Yeah. That's exactly the point, that any witness, not just Mr. Zuma, seeking to claim that right against self-incrimination would have to show good cause why they are entitled to invoke that right in relation to each specific question, and just not as a blanket answer to all questions. So I think in that context, this judgment does assist us quite a lot, and will certainly be of assistance to the Commission when Mr. Zuma appears before it.
But Lawson Naidoo, let me suggest to you that there's a likelihood that even despite the directives and the order of the Constitutional Court, if Mr. Zuma ends up sitting in front of the Deputy Chief Justice there at the Commission, along these technicalities you and I have just been discussing around the privilege against self-incrimination, the right against self-incrimination, we could have a very long 5 to 10 days of him going through these motions over and over again. Basically what I'm saying is there's a likelihood that the answers that the Commission wants from Mr. Zuma, they may not get. They may get days upon days of frustration with just going through these motions over and over again.
I fear that you may be right, Thulasizwe. Given Mr. Zuma's previous conduct before the Commission of Inquiry, his failure to respond to directives and to make statements on affidavit that have been requested from him by the Commission, he's certainly not going to go there now and fully comply, even though we have a judgment from the Constitutional Court that clarifies the extent to which he is required to answer questions. So it's certainly not going to be an easy ride for the Commission to get the information that they clearly feel that they need from him in order to complete this investigation into allegations of state capture, in which Mr. Zuma is a central figure, as has been demonstrated again this week by the evidence that's been led in relation to the State Security Agency.
Lastly, Lawson, I'm reminded, as you mentioned the word directives, that's separate from the summonses, right, that say he must go and give evidence. The directives are from Regulation 10, if I'm not mistaken, one of the sub-regulations there. It has to do with availing to the Commission documentation, specific documentation that relates to any piece of evidence. Now that that is now an order of the Constitutional Court, even if in the end there's frustration in the process to have him testifying, at least that part can be complied with, no?
Well, it should be complied with, and we know that Mr. Zuma has been implicated by at least 34 witnesses that have given testimony before Deputy Chief Justice Zondo, and he's required to respond to those issues as well. So, you know, there's a lot of work for Mr. Zuma and his legal team to do to adhere and comply with the directives and the subpoenas that have been issued by the Commission of Inquiry.
All right, thank you for your insights there. That's KSAC's Lawson Naidoo responding to the judgment in the Constitutional Court this morning. What's happening?